All right, a little bit of breaking news here today. We have an update from the FSU ACC case in North Carolina. I've got Doug Rohan from the mountains, a little bit different setting today, but Doug, I appreciate you making a little bit of time. You knew this would happen as soon as you go on vacation. There's no such thing as vacation in this world.
Yep, I
But
nailed it on the right day. I knew it'd be Thursday.
I had a feeling too. I was like, all right, the judge. I mean, come on, easy Friday. Like it'll be Thursday too. Once we got through yesterday. So thank you for joining us. Thank you for jumping in with us. We'll dive into some of this pretty intricate, pretty specific here in a moment. But give us the 30,000 foot overview of what was decided today.
Yep. Well, again, let's start with a reminder. This is the start of the case, not the conclusion. What we have today is the judge not making any findings of fact. Again, we haven't even gotten to discovery yet. All he's going off of is the pleadings, which means as they were pled, as the arguments were stated, and then, of course, the case law and how those briefs affect the facts of this case. So the judge hasn't made any determination as to who's right, who's wrong necessarily. We were just talking about whether or not the ACC met its initial obligations to file suit, whether they had standing, how is sovereign immunity going to be interpreted into this, and who had what obligations as part of this process. So FSU did win, and there are some positives that came out of this. But at the end of the day, the judge stuck with what we thought originally was the most likely scenario, and that is full steam ahead here in North Carolina.
Before we jump and dive into this, we talked about, and one of my major thoughts was that maybe the biggest reason that Florida State maybe had hope for a dismissal, not that it would come with prejudice, but was due to the fact that the ACC didn't take the vote, and that seemed to be a pretty big sticking point that could maybe, if this thing gets tried and goes on down the line, cause for an appeal, cause for it to get overturned. I know that's way down the road, and we don't even necessarily think this will go to court. But on that point specifically, is that something that you think the judge weighted pretty heavily and said, "Nah, I still just don't think it's that big of a deal," or what's your take there?
Yeah, the judge's order was 76 pages. So he was very thorough and he very much poured into his brief, his order, what his analysis of the points were. And so he did do a deep dive into all of these issues and he did do a good job explaining his rationale or his thought process. So, to your first point, the two items that are handcuffed together are standing and authority. So the judge distinguished those two things and said the ACC did have standing to file a declaratory judgment action. Yes, it's true that Florida State had not yet filed its lawsuit, but it was imminent. The judge bought the argument that it was very clear what FSU was going to do at the time that the ACC filed its suit. So the judge bought the ACC's contention that the Board of Trustees meeting was simply a formality and that there was going to be a lawsuit filed. Then the question came up about whether or not they had taken the 2/3 vote to file the suit prior to that initial filing. And the judge did extend to the ACC the rationale that authorization in that subsequent vote in January was sufficient. And if you take a step back and think about the process, you don't want companies going rogue. You don't want agencies going rogue, filing lawsuits willy nilly. But if the subsequent membership says, yeah, we do agree with that, yeah, that should have been done, then that's where the judge here is giving great deference to the internal procedures and the internal management of the organization. So, in those two aspects, the ACC came out on top, and the judge did do a deep dive into all the case law as to why he believed that the ACC had the more valid point on both standing and authorization.
Do you have a personal opinion on those? I mean, I know that you try to remain unbiased when we do these and not talk, but like obviously as Florida State supporters, as fans, we all thought like, oh, well, they didn't take the vote. Like we should just get out. Do you have do you want to take off the garnet real quick? Leave your shirt on. But do you want to take off the garnet for just a moment? And you're in the mountains, but we're still on YouTube and I don't want to get canceled. On that, do you want to weigh in one way or the other?
Yeah, I mean, again, what I wanted to see was what was the thought process? What was the rationale? What did the judge conclude? How did he reach to his conclusion? And I don't find any obvious and immediate fault with what the judge was saying. There are case laws that are supportive of both positions, both sides, and the judge simply laid out the path as to why his current argument and current conclusion is valid. Now, look, there's Court of Appeals. There are occasions where judges get things wrong. I'm not suggesting that the judge is infallible, but as long as he can logically tie together the dots and the pieces to the arguments that he wants to make, typically the Court of Appeals is going to let the decision stand. So I don't see anything right from the get go that would be problematic in either of those first 2 points.
Yeah, and I think that will not necessarily appease Florida State fans, but it will somewhat like satisfy that, like, okay, well, we understand the what, but like, tell us the why. Like, just make sure we're not getting screwed here, right? Like, that's the big thing, and it is comforting to hear that. Like, we may think one way, we may prefer one way, but it he followed a good process, he followed a good pattern, and like we said, the ultimate thing in all of this would have been they just probably refile tomorrow if he would have dismissed it today, So later on in the report, in the answer, we got into sovereign immunity and the thoughts around that. Can we talk about that just a little bit?
Yeah. So one of the things that FSU was making a big deal about was that sovereign immunity prohibited any type of litigation or lawsuit in the state of North Carolina. That effectively any complaint was barred by the sovereign immunity statutes. And the Judge Bledsoe clearly articulated his positions again that the Troy University case that was cited to earlier was sufficient to lay out the manner in which FSU was subject to North Carolina litigation. What they said was that yes, Troy University did register as a company, but we're going to take a step back, and the court never said registration was specifically a requirement. The court was just referencing registration as an example of exposing yourself commercially to the North Carolina infrastructure. Here, Florida State, as a member of the ACC, participating in meetings, flying to North Carolina to participate in committees, and actively engaging as a member of the ACC, that was sufficient to demonstrate the commercial relationship between the Florida State Board of Trustees and the state of North Carolina. So the judge read past the sovereign immunity bar and said essentially, we do have changes in the case law and we do have changes that have occurred since Maryland, but you have done enough to subject yourself to North Carolina as a venue.
It wasn't all bad news for Florida State at all, as they picked up a win within this as well. A motion to dismiss was granted as far as fiduciary duty. Can we talk about that just a little bit?
Yeah, I mean, we joked about that when it was first alleged in the ACC. I thought that was the most outlandish position that the ACC took in all the litigation up to now, and that was claiming that Florida State owed a fiduciary duty to the ACC. The judge agreed that even if everything the ACC alleged is true and was established by the facts, that still wasn't sufficient to establish a fiduciary duty. There was no way that the law could allow any version of the facts to interpret a duty that FSU owed to the ACC. So the judge dismissed that and dismissed it with prejudice, again saying, I don't want to hear anything more about this issue from you, ACC. This is a dead deal.
So this didn't go too differently than we thought it would. I mean, you had kind of projected, hey, I think things are going to kind of trend towards going full steam ahead in North Carolina. I assume, and I'll let you answer, overall thoughts here just aren't too much different. You don't necessarily feel better, worse, anything on where we are today as we move forward in the case.
Yeah, after the hearing, I felt better about where Florida State stood, especially in light of the first filed issue and the regulations requiring the vote before. But it was very clear that the judge, in his thought process and in his review of the facts, didn't want to waste the court's time with just a simple dismissal and a refile. I think that his logic was sound. I think his logic was sufficient. Basically, he said the relating back and the authorization was sufficient, and that was one of the deal breakers. We thought that if there was a dismissal, it was going to be because the judge felt more strongly on the need to vote for the litigation first. And since the judge did not feel that way, we are where we are here now with this case moving forward in North Carolina.
So I want to ask you about Florida State while we've got you. Filed
Mhm.
another update this morning. But before I do that, any other thoughts on this dismissal, anything in North Carolina before we flip to Florida just really quickly?
The last thing that the judge was really focusing on with this case is also who is the actual plaintiff. And I thought he did a good job of analyzing that because the plaintiff gets a lot of deference as one of those factors as to where the suit is going to be filed. So the judge was agreeing with the ACC perspective, which was Florida State is threatening to sue. Florida State has said they want to get out. Florida State wants to breach the contract. So effectively, the ACC, who is also facing an existential crisis in this litigation, is the true and correct plaintiff, and therefore the case should stay in North Carolina. So, in reviewing the factors, not just the first filed, but also this concept of the true plaintiff, I think that it's a valid argument that the ACC is the aggrieved party. Now, Florida State has arguments as to why that's the case, and that goes to your filing in Florida that we talked about, and Swafford and Phillips not doing their job and holding up their end of the bargain. And that's where we get into the breach of contract. That's still the main focus of this claim going forward. Again, no findings of fact were made other than the determination that the ACC could not meet its burden to prove a breach of fiduciary duty. Everything else was just based on the pleadings, and the judge said, well, the facts were laid out in a sufficient manner. Now let's see what the actual evidence is going to lay out.
What's our timeline for North Carolina now?
Now we go back to having absolutely no clue. April month, I assume that we're going to be in scheduling order next for the discovery phase. Again, we'll see what happens in Florida on the 9th, on Tuesday. And then from there, do we have two competing lawsuits that then needs to get resolved through potentially the federal courts? Again, I still don't have clarity on that. I still don't have a guarantee that that's the path that we're going to go. But let's start with first seeing what happens on Tuesday, April 9th, with the Florida hearing and the subsequent order, which will likewise take 2 or 3 weeks to
Yeah.
be issued.
Just let me know if you have another vacation scheduled. It'll probably be right then. Shout out to Matt Baker with the Times who put this out today. He said the latest Leon County filing by FSU versus the ACC is a little bit on the spicy side. The quote reads, and I'll put this on the screen so people can read it as well. The FSU board's contention is that the entire ACC enterprise has failed, particularly in its constitutionally committed to purposes, as well as the fact that the captains who guided it, Swafford and Phillips, have run the enterprise aground, plagued by conflicts of interest, motives of self-perpetuation, and the abject abandonment of their preeminent responsibility to serve the members first. Those commissioners have skippered the enterprise to the existential brink. I'm really just impressed that I did that all in one take, but I was really focused, though. So any thoughts on them firing back today and getting a little spicy, as Matt said?
Yeah, I haven't read the specific filing, so I'm curious as to why there was something even being filed at this point, this close to the hearing. But that is laying out, again, what is the basic issue for this trial, for this hearing. Did the ACC, through its commissioners, breach its obligations and therefore breach its contract with FSU to try to achieve financial success, to try to achieve superiority on the part of the ACC within the conference structures? So Florida State is just, again, narrowing down this specific point as to what it is that they are trying to establish in this litigation.
Would it surprise you at all, big picture, if all of the the wins or the motion to, like, you would be pretty surprised, I would assume, if Florida dismisses it? Do you think really over the next couple of weeks once we have the hearing on Tuesday and then the answer from the judge? I mean, maybe just kind of see a mirror of what's happening in North Carolina would kind of be your guess there.
98% chance that's the path we're on. That's most likely what we're going to see.
Would you think that that judge as well? Again, I'm asking you to speculate a lot here. Ends up calling Florida State the true plaintiff in this case.
Sure, the judge could be reading again. You're just where are you looking on the timeline? Judge Bledsoe in North Carolina looked at this case on December 20th of 2023. Where did things stand on December 20th of 2023? Florida judge could look back and look beneath the layers of this original complaint, saying, Florida State was really the plaintiff, the aggrieved party, as of 2016, the second time they signed the grant of rights. It just depends on your perspective and where you're looking at it. Two people on either side of the parking lot looking down at the asphalt. One sees a 6, one sees a 9. They're both correct. They're just looking at it from different perspectives.
Oh. Doug, I appreciate you for joining us. I know that you're in the middle of vacation, so we'll let you get back to that now. Tell us a little bit about Rohan Law, and then we'll wrap up and get out of here.
Yeah, Rohan Law in Atlanta, Georgia. So come on by and see me if you should get in any trouble. We want to make sure that you're protected and your rights are protected. At Rohan Law, we practice primarily in workers' compensation accidents, criminal defense. So if you've been arrested or you've been hurt at work, then Rohan Law is your team. I know everybody listening to this is never going to need me because it's a bad day if you need me, but your friends or your family might, and you want to make sure that you pass our information along to them so that we can help them out.
Yeah, Doug's also very active with the Atlanta Noles. If you're in or around that area, make sure that you go by and see him at all the ATL Seminoles Club events. You guys have a great club up there in Atlanta and do a great job. So, Doug, thank you so much for joining us. Enjoy the rest of vacation. We'll see you soon, but not again while you're out in the woods. So have a great one, man.
Take care.